Here's Nicole Wallace.
To sort of steal Ari's analogy, one person has to write like Shakespeare, the other one like a Trump tweet, right? But I don't even think they did that. And what the prosecution had going for it today was the ability to say, take the sex. Sex happened in 2006. Why do you think they paid for it 2 weeks before Election Day?
Shakespeare. It was Shakespeare, whereas that loser defense attorney only had to come up with the equivalent of a Trump tweet.
I turn it on at night. It's been my habit for many years, as you know, and I don't know, Alan shares my frustration with this. I don't know what's happened to the party that I grew up with. When did they flip and become cheerleaders for the prosecution? When did all of a sudden everything that Alan and I were bitching and moaning about in the 90s when Republicans were coming at Bill Clinton during Whitewater? I mean, I remember trying that case with Susan McDougal back in Little Rock, Arkansas on obstruction of justice and contempt charges and saying to myself, this is so outrageous. I can't believe this. What a political show trial, blah, blah, blah. Everything that we were saying, and Alan was that's where we bonded in the 90s. Everything we were saying then is what's happening now, but it's just a shoe on the other foot.
Mm-hmm. Sure, Professor Lawrence Tribe is the leader of that pack. It's only good if it's good for the Democrats. This is the perfect case for why all trials should be televised. We should be able to have seen Judge Marchant. We should be able to have seen all the actions, all the witnesses, and be able to judge for ourselves instead of having to see it through the prism of CNN and MSNBC. When you flip the channels, it's as if you're seeing descriptions of two different cases. They bear no resemblance, and the American public has the absolute right to make its own judgments. Who are you going to believe, me or your lying eyes? And I would hope that this would increase the movement toward having trials, particularly trials of this dimension and magnitude, on television so that everybody can see it. Mark, I think you'll agree with me. We've done trials, both of us, that have been on television. You don't even remember that the camera's on. You focus so much on the fact finder, whether it be a judge or a jury. I argued some of the motions in the O.J. Simpson case on television. I argued the appeal in the Von Bulow case, which was on television. Never occurred to me in a million years to focus on the cameras. I wanted to focus on who was going to decide the case. So this is a perfect case for why everything should be on television.
It's also interesting, Megyn, I think I mentioned this before, Shepard v. Maxwell, which is decided some 70 odd years ago, was the U.S. Supreme Court case that talked about and was originally designed, and that's where F. Lee Bailey, speaking of the O.J. Simpson case, made his career on, or the first thing that catapulted him into it. That was originally designed to protect the defendant. And it has been so perverted over the years into something that is virtually unrecognizable, where now we do not televise. And one of the biggest mistakes I ever made in Scott Peterson, I've said it repeatedly, is that I agreed with the prosecution not to have cameras in the courtroom. There should have been cameras in the courtroom, because I would go home at night and I would watch people reporting from New York what was happening in the San Mateo County, and it was unrecognizable to what had actually happened in the courtroom.
Right.
That's the same thing. Alan's kind of summary of what it is happening now is the exact same thing. I can pick up or turn on one. I know instantly by where the source of the news is, what their spin on the case is. I can't get an accurate, any kind of an accurate historical view of what actually happened in the courtroom unless you read the transcript. And even then, that doesn't tell you it doesn't give you the nuances.
I know, it's very frustrating. I want to say one other thing. Let me say one other thing. Jonathan Turley, who is a legal contributor on Fox News, he was raising a point. I'm just following up on her Shakespeare comment. So Shakespeare, also known as Steinglass, the ADA, got up in front of this jury and lied. He lied repeatedly in that closing of his, and Turley did a great X thread on it. For example, saying that Steinglass got up there and said it is a fact that these were campaign violations, that the federal law had been violated. Nothing from the judge, reading here, quoting, nothing from the judge and nothing from the defense. This jury's now been told dozens of times that the payments were campaign violations, and the judge is letting that false claim stand uncontradicted. He literally said that Trump lied in denying that these were campaign contributions because they were, in fact, campaign finance violations. Judge Merchan is treating all of this as argument. However, Steinglass is making a statement of law that is contradicted by a wide variety of experts. Of course, we all know those experts were denied entry to this courtroom to actually instruct on the law. And when Judge Merchan took a shot at it, defining what the federal election law actually does require, he whiffed and did not state the accurate description of how we determine whether something falls within the campaign finance laws. It has nothing to do with the defendant's subjective belief or desires in paying it. It has only to do with the nature of the payment. Is this the kind of payment that can only ever be paid within the context of a campaign, polling, rallies, that kind of thing? Or is this the kind of a payment that might be paid to advance a campaign, but also is made many times outside of the electoral context? That's a hush money payment. That's this case. Go ahead, Alan.
No, the prosecutor made a serious mistake, which will result in reversal if this conviction, if there is a conviction. He said that it's a fact. If it's a fact, then you are allowed to have expert witnesses to dispute that fact. The only basis on which you can't have an expert witness is that it's the law, not a fact. But if the state I would open my brief that way if I were doing an appeal. The state has conceded that the issue of whether or not this was a campaign contribution is a fact, yet the judge excluded a fact witness. That over objection. That's clearly reversible error. But, they're so arrogant. They know that this is Trump and that whatever the law is for other people, it doesn't apply to Donald Trump. But once you allow that to happen, the next person it doesn't apply to could be you. And that's why this is so dangerous for all Americans and why some decent civil libertarians who are Democrats or liberals are so upset about this, and they're not following the path of Professor Tribe and others for whom the only issue is it good or bad for the Republicans or the Democrats? When I used to come back from a baseball game, a Brooklyn Dodger game, I'd say to my old grandmother, who was a Polish immigrant, "Grandma, the Dodgers won." And she would say, "Yeah, but was it good or bad for the Jews?" And that's the Lawrence Tribe. Is it good or bad for the Democrats? If it's good for the Democrats, it's the law. If it's bad for the Democrats, it's crazy. It's bizarre. And that's the language he uses. He has totally become a partisan when it comes to the law. And, you must maintain neutrality. And I hope Mark and I and you, Megyn, are among the few that maintain a kind of neutrality and objectivity without regard to the partisan implications. It's so important that those principles remain intact.
Yeah. All right. Well, I know you don't like to give predictions, Alan, on what a jury will do. You will predict what a judge will do, and you have either a perfect record or almost perfect record. But, okay, so on that note, I'll start with Mark. Mark, any predictions on what this jury is likely to do, how it's likely to come out? I won't hold you to it because we all know none of us knows anything on this front.
The one thing I do know is that jurors in cases like this generally will come back Friday afternoon after lunch. And if they don't come back Friday afternoon after lunch, then the odds of a hung jury are much greater. You've got, as we sit here today, you've got basically 55 hours for them to not deliberating the whole time, but until you get to Friday after lunch. But Friday after lunch, 3:00-ish is the bewitching hour. If they
that's good.
They don't convict by then I think the odds of a hung jury increase dramatically if they come back next week.
Let me tell you a story about a guy named Leo Grillo. Leo was on a road trip and came across a Doberman. This dog was severely underweight and clearly in trouble. Leo rescued the dog and named him Delta. But sadly, Delta was just one of many animals that needed help. And this inspired Leo to start Delta Rescue, the largest no-kill, care-for-life animal sanctuary in the world. They've rescued thousands of dogs, cats, and horses from the wilderness, and they provide their animals with shelter, love, safety, a home. April marks 45 years since Leo rescued Delta. Delta Rescue relies solely on contributions. If you want caring for these animals to be part of your legacy, speak with your estate planner because there are tax benefits here too. You can grow your estate while letting your love for animals live well into the future. Check out the estate planning tab on their website to learn more and speak with your advisor. We call dog a man's best friend for a reason. You can help those who need it most. Visit deltarescue.org today to learn more. That's deltarescue.org. Hey, thanks so much for watching. If you like what you just saw, hit the subscribe button for more clips and full episodes.